welcome to Top Intellectual Property Mistakes Made by Startups. We're really happy to have Dan Holmander back this year. Dan led this session last year, and it was very highly rated by our attendees. Perhaps a lot of pitfalls avoided based upon advice doled out last year. Dan's back this year with two colleagues of his from Adler, Pollack, and Sheehan, and they're going to help you avoid some of those classic pitfalls in protecting your IP. Adler, Pollack, and Sheehan is a 50-plus attorney full-service law firm, the largest law firm here in the state of Rhode Island, and they have a special focus on patent and trademark law. AP&S has 10 patent attorneys and trademark attorneys. On average, the IP practitioners at Adler have 20 plus years of experience and advanced degrees in a variety of technical areas, such as life science, biotechnology, chemistry, software, and the mechanical arts. Dan, thanks for being with us again this year. Really great to have you back.
Well, thanks, Pat, and thank you all for attending today's session. I know that you all came here to learn about the top IP mistakes made by startup companies. But before we get started, I want to introduce myself just for a second, and then also my two colleagues. So my name is Dan Holmander. I'm a registered patent attorney here in Providence, 20-year plus practitioner. Again, wide range of technology areas, focusing really on IP monetization strategies and really developing those IP strategies for especially early stage companies. And I'm going to say to my right, because that's what it looks like on my screen. But we have Murali Rajagopalan. Dr. Rajagopalan is a technology specialist here at Adler, Pollack, and Sheehan. He has over 30 years of experience in the polymer industry, 27 years spent at Acushnet, where he had over 250 US patents on the Pro V1 golf ball. And I say that he's the guy that invented the golf ball, which is not true, but he's pretty close. He also has a PhD from McGill University in polymer chemistry. And then to the right of Murali is Dr. Michelle Moore-Mike, my good friend, Mike Morency. Mike has a PhD also in medical science, specializing in neuroscience, 25 years of experience in life science clients ranging from early stage to IPO. Mike's actually taken a few companies IPO. And he really specializes in advising clients in the creation and development of IP portfolios in his area of focus, which is so numerous, but neurobiology, stem cell technologies, immunology, vaccine technologies, novel antibiotics, blood products, drug discovery, drug delivery. I mean, it goes on and on and on. So today, these two gentlemen and I are going to help you articulate what we think are the top IP mistakes. And in the agenda that we sent out in anticipation of this class, we actually have already highlighted those. And just for your identification, you don't need to write all this down necessarily, because if you want, you can send an email to me, dholmander@apslaw.com, or Denny Charlotte at RISUW, or Pat, or anybody at RISUW, and we'll get you a copy of this presentation. So I want to get started right into it. And by the way, for those who have questions, we're going to leave a good amount of time at the end of the session so that we can get to those really juicy questions at the end. But let's start off with talking about inexpensive patent applications. And Mike Morency, do they really cost as much as they say they do, or is there some hidden cost behind inexpensive patent applications?
Well, one of the mistakes that early stage companies make, they don't have a lot of cash on hand. So a lot of times they'll try to prepare the application themselves or go for the cheapest option, one of those providers that advertises getting you a patent for $1,000. And they're usually both have serious pitfalls in that there's very established requirements on the written description side, in the enablement side of the equation, where if your application does not meet those requirements, you can lose your priority date. So you file a provisional application, you think you're safe, you start either publishing it or disclosing it publicly, and you find out when it starts examination that it doesn't comply with the requirements, and you don't get your priority granted.
Hey,
So
Mike,
one
can
way
I
to
ask, can I
sure.
interject a question there? So for the audience here, early stage companies, I have no money, and somebody says, hey, why don't I just file it myself? Why can't I save some money? What's wrong with that? Or what's good about that?
Well, the good thing about that is, I like to have, my clients involved in the writing process. But they should always have a registered patent attorney review it to make sure that it meets all the requirements. And we work with early stage companies all the time that, are not flush with cash. And there are ways to still get a good product, but, really keep the budget at an acceptable level for an early stage company. The worst thing you can do is just, go at it alone and find out later that you didn't get your priority date. So work with your attorneys. They can help you make it, a cost-effective process. But, the pitfalls of not doing that can be great. The other issues that I've seen with early stage companies, the other mistake is when they license in technologies from, let's say, a university or a nonprofit hospital. They assume that everything is in tip-top shape. A lot of universities and nonprofits, work with law firms at, volume discounts. And what that means is, usually you get pushed down on a very limited budget. You push the work down to the more junior people that have lower billing rates, and you can't assume that the quality is there. So again, if you have in-licensed technology and IP rights, patent applications, you should again have, a registered patent attorney have a look at it and make sure. I've caught clients where the application was about to publish and it was incredibly narrowly limited, and we were able to file a broader application before the first application that had licensed in published. And that way, that publication did not hinder them from, broadening the scope of the application.
Excellent. Well, listen, let's go on to the next topic, Mike. Chain of title. It sounds like something I'm familiar with. Chain of title, when you're talking about, let's say, a car or a house, but you have to think about that also in respect to inventions too. Why?
Well, the first thing that, when you go for financing or when when other third parties do due diligence on your portfolio, the one thing that they will look for is to make sure that the inventors have assigned their rights to the company. And a patent application belongs to the inventors until they assign their rights to your company. And that's an important point to keep in mind. The tricky part is that you don't need the assignment to file the application. So a lot of times that's sort of pushed to the side. We'll deal with that later. And, I could tell you a lot of nightmare stories, but sometimes, an inventor will leave the company and it may not be under great terms. And now you're chasing somebody who's quite reluctant to help you in any way. So, or somebody just disappears off the face of the planet, apparently. Today it's harder to do, but, I've had to hire a detective service to find an inventor in one case in the past. And then other times, one of the inventor passes away and now you have to deal with the estate to try to get the document executed. Needless to say that it's better to get it done from the outset. And you don't want to be surprised in a due diligence process where now you have to chase for a document to get signed and you're having issues. It can really delay the financing or the transaction.
Yeah, Mike, I was thinking about the audience that we have here. They're looking for seed funding, right? So what kind of impact will it have on their process if they're looking to get seed funding from a company and there's a chain of title issue? What kind of complications will that occur?
It can range from, get it cleaned up as soon as possible, or we're not going to give you the money until it's cleaned up, right? Yeah. So, you want it, to have it in the, in order before you get into the process. The other ways that you can mitigate that, usually companies get their employees to sign an employee agreement. And, oftentimes I'll ask them, do you have an IP provision in your agreement? And they go, we don't know. So I will review their agreement and make sure that there is an IP provision where the employee realizes from the outset, if they invent anything while working for the company, it belongs to the company. And at times where inventors are reluctant or disappear, you can actually file that agreement with the provision to establish title. It's better than nothing. It's at least it sort of makes the issue go away. It's not perfect. It's a lot better to have an assignment, but it can help out. The other issues that I've seen with clients is a lot of times, especially today, they hire contractors because it's, a lot cheaper than building a brick and mortar operation. Why not use a CRO, contract research organization? And what, the company has to realize is the IP belongs to that contractor until it's assigned to the company. And so
Mike, so you're saying that if I hire, let's say, again, we have a wide variety of technical areas here. Let's say it's a software app and I hire a team of developers and they end up executing and providing line code for me. Could they potentially be inventors and therefore co-own part of my IP?
Correct. If it's the inventorship is, it's determined by what is claimed in the application, and it's a very factual determination. If they're deemed to be an inventor, then the inventor owns the rights, but they probably have an obligation to assign it to the contractor. And the contractor then owns, co-owns the application if it was a co-inventorship issue.
Wow, that's tough. And so I give somebody $100,000 and I still don't own the IP. It's tough to take sometimes. All right, well, listen, Mike, let's go on to the next topic here, novelty requirement. And that's a real technical legal word, which means that the invention can't be in the prior art, which is another technical legal word, lead to one. And be wary of public disclosures. Can you talk a little bit about why public disclosures are bad in the patent attorney world?
Yeah, so, if once your invention is in the public domain, out there available to the public, you can't get a patent on it. A patent is a bargain between the government or the public and the inventor, and they give you 20 years exclusion, but in exchange, you have to fully disclose your invention, and it has to be novel and not obvious over what's out in the public. And so it's very important that you don't shoot yourself in the foot by publishing before you file the application. And where I've seen, especially startup companies, make mistakes, usually the initial technology, they're quite diligent about it. They will, get it filed, but sometimes they will publish a paper and they say, well, it's not going to be published for several months. And what they don't realize is sometimes the publisher will publish an abstract online or part of the article online ahead of the publication date. So it's not worth taking the risk. It's better to just file, even if you just file the paper as a provisional, but then beef it up with a more substantial provisional later. It's not worth risking because it's an all or nothing proposition. The other area that I see companies getting in trouble is they make an improvement and they, don't really assess whether that improvement is patentable, and they just start talking about it or presenting it. And next thing you know, it's no longer patentable, and it could be quite commercially valuable. I had a situation where I was asked by a company that I wasn't their IP attorney to do an infringement analysis because they had been threatened by somebody else's patent. And I came back after a deep analysis, and the answer was, and they were very upset because they had licensed a patent to cover their commercial activity. And I came back and I said, well, it's a good news, bad news proposition. You don't infringe their patent because of X, Y, and Z. So you're not in trouble with the third party patent, but your own licensed patent doesn't cover your technology. And when I explained to them, they said, oh yeah, we improved that, 3 years ago, and they never bothered to patent it. So their actual commercial product was no longer covered by the license. And of course they couldn't get a patent, having sold the product for 3 years after, they had done the improvement.
Oh. Well, listen, Morale, you have some experience in this area, and your vast chemistry experience. Can you tell us a couple of stories in your world about the novelty requirement?
Yeah, I think it's a good beginning what Mike said. For example, people say that, hey, how can I have my invention as a novelty? In one case, we all know that a flexible PVC based on plasticizers such as dioctyl phthalate or dioctyl adipate is commonly used in medical device IV tubing. Okay, then people say, hey, how can I get my invention? Because it is based on PVC. It is not based on DOA, not based on DOP. Can I still file an invention disclosure? Or can I still have a patent application? The answer is yes, as long as the new plasticizers got some novel chemistry, which is not known in public. Okay, that's a key thing, not known in public. And you add some value added ingredients into a
secret sauce. The secret sauce.
Exactly.
Right.
That's and make it something unique, and so that it outperform the current technology. I think that's a key thing, and you bring value to your invention.
So you're saying you can take existing technologies off the shelf. Let's say it's a chemical that's supplied off the shelf,
right?
Combine it in a new configuration, and then that's patentable. Is that what you're saying?
If the ingredient you're putting it together, the new chemicals, is novel, and also the composition range. For example, you find a window where that composition range gives you the unique properties which is unknown in the real world. That is patentable. I think Mike and you can add, I can get a patent. What does that mean? Can I practice? That's something you will add to it later.
Well, the point here is that a lot of times I've had clients tell me, well, we can't get a patent on this because of this other patent or this, paper that was published. And, in our hands, we can find ways to find something that's patentable when the client didn't think it was. They thought they were blocked by, a certain prior art reference. Yeah. So people like Morale are very clever at finding ways to get around the prior art references and find something that's still patentable and commercially valuable on the patent side.
Well, I'd say a guy that has 250 patents to his name, you must know a lot about patents, Morale.
Oh, yeah, I was very fortunate. I'm blessed. Absolutely.
So, Mike, going back to the novelty requirement in public disclosures, is there anything else that we should be aware of?
I think we've pretty much covered that topic.
All right, let's go on to freedom to operate, Mike. So that's a great phrase. And I always, when I talk to clients, those are kind of those expensive words that you utter at a certain time, right, of the stage of the company. And for these early stage companies, do they need a freedom to operate right away? Is that something they want to start out with? Hey, I want to have freedom to operate, or what's a good time for that?
Yeah, so one mistake, clients make, they say, well, we've got, a patent on it. We don't need to do a freedom to operate. And they don't appreciate the difference between the two. A patent doesn't give you the right to do anything commercially. It gives you the ability to exclude your competitors from what is within the scope of your claims. Okay, so you may have a patent on something, but you still need to get the rights from another patent owner in order to commercialize your embodiment. So, keeping that in mind, it's good to get a freedom to operate opinion as early as possible. And the opinion, let me rephrase that. The other mistake is that, companies go for the expensive opinion. And, I've often asked my clients, why do you think you need an opinion? Well, the investors will ask for it. And, they don't. They ask if you are aware of any freedom to operate impediments. And so what I always advise my clients, the early stage especially, is look, get a very good search done, a freedom to operate search. And those are a lot less expensive. As soon as you ask an attorney to write an opinion, they have to give you the full-blown opinion. They can't do a partial opinion or a cheap opinion, because their firm is on the hook for if something goes wrong. So, putting an opinion down on paper, you're talking, $20,000+, whereas you can do a very good search, anywhere from a few $1,000s to, let's say $1,000 to $4,000 is usually what a good search involves, and sometimes less. It depends how narrow your commercial activity is and how precisely you can describe it. So the answer is, you should have a good sense if there's any freedom to operate impediments as soon as possible. And, you don't need to blow the budget on an opinion. That, that an opinion should only come in place when somebody's alleged that you're infringing their patent. Then you need,
Mike, what I hear you saying is that, like, again, as an early stage entrepreneur, if an investor comes to me and says, hey, do you have freedom to operate? It's not to say yes or no necessarily. It's more about what are they really worried about, and then getting to the root of that, and then maybe meet with your patent attorney to say, what is, again, based on a limited budget, what we need to do in order to get that answer. Is that what you're saying?
No, I would do it earlier than that. So when the investor asks you, do you have any freedom to operate impediments? You can say, well, we did a very thorough search. We retained this firm to do the search. They may want to see the search results. And then we can discuss, with our patent attorneys, any, patents that you're concerned about. So you do it verbally. And that's a lot less expensive. The other concern that I've seen, mistakes that I've seen, is when startup companies license in technologies or patents from a university or a nonprofit, they assume that, it's all clear to go. The thing is, universities and nonprofits do not do freedom to operate analysis. So, and it's in their license agreement, caveat emptor, we're not guaranteeing you the patentability, or we're not guaranteeing you're not infringing somebody else's patent. So don't assume that you have freedom to operate because, that it's been done by the university or the nonprofit, because you could have a big surprise later on.
Excellent. Well, Mike, listen, in the interest of time, I want to keep us on track here. So I'm going to have to move to the next topic, if that's okay.
Sure.
Intellectual property strategy. Strategies, some work, some don't. There's a lot of myths out there, Mike, about filing everything or don't file on anything. I think I read a book one time and said, don't patent anything. What's your perspective on that?
Yeah, there's frustrations from startup companies that, why should I bother getting a patent, because I can't afford to sue anybody for patent infringement. And my my answer to that is, try it without patents. Nobody will fund you. Nobody will invest in your company, and somebody will take it from you, improve it, and get a patent on it. So the one thing that you need a strategy, because it can get quite expensive. When you start getting multiple applications on file, and especially when you start getting to the stage where you have to enter into foreign countries, you need to, and you'll have patent attorneys tell you, well, this is your last chance to get into Scandinavia, in South America, and India, and China. And, if you don't have a strategy that protects your IP where it makes commercial sense, you'll end up spending a lot of money with really little return. The saddest diligence I ever did, a client of mine was acquiring a portfolio for an anti-Parkinsonian drug, and it was their attorney was a big New York law firm, and I had a sense, I thought of what was I needed to look at, and I thought it was maybe 6 to 8 files. I showed up in this New York office, and it was a huge conference room with wall-to-wall files, 3 feet deep, 3 feet high. And I said, whoa, I didn't expect to have to review this much. And he said, no, all these files along the wall are, abandoned. The ones on the table are the ones that are still alive. So they had wasted all this money, time, and resources. And when they ran out of money, they had to abandon, a lot of application they had filed. So that's a waste of money in my book. So the best way is to have a strategy that makes commercial sense, that you can explain to an investor, we're filing in this and this and this country because this is our intentions for commercialization, and keep it consistent across the families, and make exceptions where it makes business sense.
Mike, do you think provisionals are a great way of saving money as well?
They are for certain technologies. If you have a technology that will be commercialized within 6 months and obsolete within 2 years, provisionals don't make any sense. In the life science space, they make absolute sense because they don't count against your 20-year term. So you're effectively lengthening your patent protection to 21 years. And it gives you a year to work your invention and file the second or a third provisional if you see improvements before you have to convert at the 1-year anniversary.
Good tip. So the next topic we want to talk about is other forms of IP. And so right now we've really been heavily focused on patents. I'm just going to talk a little bit about some of the other forms of protection that you should be aware of, especially as an early stage company, because these other rights, patents really are, in my opinion, the most expensive rights to acquire, okay? But when you talk about copyrights, trade secrets, and trademarks, just to kind of give you an idea, you can have a copyright, you can have a trade secret, you can have a trademark without actually having to file anything. Think about that. Whereas with a patent, you actually have to go to the patent office to get a patent. There's no such thing as these, old wives' tales about mailing stuff to yourself or whatever that is today. You actually have to go to the patent office to get a patent filed. These other rights you can do today. So for instance, if you create a website, you have a copyright on the text and images and how it's arranged. If you create software, you can patent it, but you can also get a copyright on the source code upon creation. You don't have to do a special act. Now, if you want to perfect your copyright, you can register with the U.S. Copyright Office, and we do recommend that. But if your budget is limited, you don't have to initially. Trademark, same thing. People will say, all right, well, I want to go get a trademark. I want to protect it. It's a great idea to protect your trademark. And more importantly, though, clear your marks. Make sure that they're available for use and registration. Because a lot of times people pick names they like based on what was available at their domain register, like GoDaddy, based on some catchy phrase that they heard. Check to make sure that you have those rights available to use and register. And then you can at least use it on a common law basis. But I'd recommend still filing it at a federal level so you have protection in all 50 states. But you should definitely be aware of the fact that you don't have to today. It's not quite the same as patents where you have an expiration date. If you disclose, think about it at a high level, you're going to lose something. Not with trademarks, not with copyrights. And the last one is trade secrets or know-how. And there's a lot of stuff that every company, I've heard someone once say to me, oh, my clients don't have any IP, right? And I'm like, every customer, every company, every client has intellectual property. At the very least, you're going to have know-how or something what we consider to be a trade secret, internal processes, information that you don't want disclosed to others because there's economic value. Think of something really basic. I like talking about really basic things like chocolate chip cookies. If you had this really incredible recipe for a chocolate chip cookie, there's really no other way to protect it than by maintaining it as a trade secret. Don't tell anybody about it. Restrict access internally. Make sure that it's password protected. The great example is the formula for Coke. It's in the side of a mountain in Georgia in a gold vault with very restricted access. That's what you need to do to your trade secrets. And remember, these aren't mutually exclusive rights. As I've already said, whether you're doing a patent, a copyright, trademark, or a trade secret, or a trademark, they're not independent. They're mutually dependent on each other. If you have a business that you said, look, there's nothing really inventive here. We can't get a patent, but we do have some internal process. Let's call it method of manufacture. Well, let's make sure that we protect that when we have our contractual relations with our vendors or outside organizations. If we truly have nothing novel, maybe it is just about the brand. Think of like lifestyle companies like Life is Good. So those are some extra tips. Mike, do you have anything else to add to that?
Yeah, the only thing that I would add is that understand that in order to have a trade secret, you have to implement specific procedures to protect that trade secret. Otherwise, you don't have a trade secret. You have know-how. And, it's if you're going to promote the fact that you have a trade secret when you're raising money, I always use this example. I was helping a client go through the IPO process, and we were doing the diligence call with a banker's attorneys. And they asked, do you have any trade secrets? And the CSO says, yes, we do. And I had to stop him and say, no, we don't. We have know-how. And after the call, I had to explain to him, you have not put any measures into place. The next question was going to ask you about what procedures you had, and you have none. So there's no sense in setting up this false expectation that you have a trade secret when you have not protected it. Now, other companies I've helped build, a lot of their protection on trade secrets, and it can be quite valuable.
Excellent. Non-disclosure agreements, confidentiality agreements. I'm sure everybody in this call has heard those phrases before. Mike, what's your take on NDAs, CDAs, all these different lingo on these words? What do you think of those, and how important are they to a company today?
So, the mistakes I've seen is, clients will say, well, things are moving so fast. We don't want to slow it down with an NDA. And that's a really dangerous proposition, because from a startup, perspective, they're going to be the ones disclosing. The larger player is, talking to them because they have innovation that they may be interested in. So it's going to be disclosure basically going one way. And understand that if you disclose it without an NDA, that's a public disclosure. So right there, you're pretty much shooting yourself in the foot for your patent protection, unless it's been filed before the meeting. But even then, you want the NDA in place. And this, the second mistakes clients have made is, well, the larger player gave us their NDA, and so that's okay. We're just going to sign it. Well, sometimes there's provisions in those NDAs that are, quite damaging. I remember one large New England company, which I won't name, had a provision in their NDA that you could only, if you sign the NDA, you could only ever enforce against them issued patents, not pending application. And my client only had pending applications. So I said, why would you sign this? And we tried to take out the provision. They would not. And I said, just walk away, because you're giving away the farm. Okay. And the other mistake that clients will make, startup clients will make, is they think we've got an NDA in place, we're free to disclose everything. And for me, it's disclose as much as is needed, but don't disclose everything. It's just on a need to know basis. And also understand what's in the NDA. If only the written product is protected, understand that your conversations will not be protected. So you need to understand what's in the NDA. It's better to have one. It's not an absolute protection, but you certainly want one in place before you start talking to a third party.
Yeah, the one thing I'll add to that, Mike, I agree with everything you said, is that you need to document what you discussed.
Yes.
A lot of people get NDAs and it says, I talked about this invention, and it's like 3 words. And now 3 years later, you discover they've violated the NDA, and now you have to go back in time and remember what the conversation was about, because there's nothing attached that's written or a follow-up summary of what was discussed. There's nothing that's anchored to the NDA, and it becomes a he said, she said situation later on, which makes it really hard to enforce. So my thing always is, look, if you have a patent application, it's filed. And to your point, Mike, you don't want to just attach the patent application, but maybe you create a summary of that, and maybe you include it as an exhibit in the NDA, or something that's centrally focused on what was disclosed, because otherwise you're going to have a hard time enforcing the NDA. I don't know what you think about that, Mike.
I agree. And the other thing is that understand that the NDA has a certain term, okay? And usually it's between 1 and 3 years. And I had a client in a situation where they were talking with a very large player. They had a new device, and I won't describe it what it was, but so, and the discussions went on for years. And at the end of the process, they came to realize that the large player was talking to 2 companies that had similar but different approaches to the same problem, and they actually partnered up with the other company. So then they came to me and they said, well, can we enforce the NDA? Can we force them to return everything? And we came to find out when they sent me the documents that they had, there was a lapse of months between NDAs. Some had lapsed, they'd put another one in place, but there were gaps. And it really wasn't your exact issue, Dan, specified. They had not recorded what they had transferred as far as information. It was a mess. And I said, we have strong patent protection because I was their IP attorney, now their transactional attorney. So we're going to be okay. But it made me realize how bad it can be when I'm not involved in that process. Because a lot of times, clients will say, well, we'll just grab something we got from another company and use it again, and that can be problematic.
Mike, it's all online, right? Everything's online.
Yep.
You just take whatever's available and that's it. I will say, just as a note from an Adler Pollock Sheehan standpoint, that people, early stage companies, we do a lot of pro bono work in this community, and people have asked me, hey, can you give me a consult, and maybe, can you look at an NDA, here or there? We've done that. I mean, that's something that we would help people, because we understand the situation you're in, and it's a good entree just to get to know us a little bit better. So just kind of plant the seed there. Let's go on to strategic partnerships, Mike. And I know you know a lot about this topic, and this could probably be its own session unto its own. Talk about LOIs. How important are they, and how important are they to do right the first time?
Well, yeah. So the one mistake, a common mistake that companies will make is they'll say, hey, let's just negotiate the terms, and we'll bring in the attorneys when we start drafting the agreement. And they don't realize that the larger player will want to memorialize, the terms that they've negotiated into either a letter of intent or a term sheet. And even if it's not binding, it sets an expectation. So I've had nightmare situations where I was brought in and the client had not realized that, the letter of intent was 200% in the big player's favor. And now you're pushing back against a cement wall because they go, well, that's, you try to change the agreement, the final agreement, to soften those terms in the letter of intent or the term sheet. And they go, no, that's already negotiated. Can't go back on those terms. And you're really fighting an uphill battle. The other mistake that clients make, and I understand it, they go, well, having my attorneys draft the first draft of the agreement, whether it's a strategic partnership, it's a distribution agreement, whatever it is, let the big company, they have attorneys on staff, let them draft it, and then we'll get our attorneys to review it. So those larger players tend to put things 200% in their favor. I don't want to disparage all of them, but a lot of times they use the most favorable provisions for themselves. And now again, we can push back, but you're fighting an uphill battle. Whereas, I prefer to take, to do the first draft and make it a lot more reasonable, and sometimes make things that are a little bit more favorable for my client, but not being unreasonable, because, we don't have the leverage as the startup company. But it's a lot easier than getting an unreasonable agreement. Now you have to push on dozens of provisions that could be problematic in the future. So, and another mistake that I've seen clients use when they're a little bit further advanced, they say, well, we did, a strategic partnership or a license agreement with that company. Now they're doing another one. They go, well, we'll use the agreement from the previous one and make it fit in this situation. Just change the names and the patent numbers, whatever the situation. And they don't realize that, drafting an agreement, you can get to the same end result in many different ways. And a lot of times you concede points and you make things weaker or more in the favor of the other party because it was done through negotiation. And just taking that situation and applying it to the new one may not, suit it well. And you're putting a square peg in a round hole, and it could cause problems.
Excellent, Mike. Well, listen, I think there is a lot of information there. Oh, Pat Sabatino's back. Pat.
Yes. Hi, Dan. Well, this has been a great session and a lot of fantastic content. For those watching, you can post questions in the chat. I'm going to tee it off actually by asking my own question. Okay. And this is not really a pitfall question. It's a question of what happens after you've already had the pitfall. So I founded my company back in 2015. And I had originally raised $350,000 in convertible debt and hired my first engineer, and I got a working prototype up and running, and I thought life was awesome. And then this is before I had met AP and S. Maybe I would have got better advice. I don't know. We'll talk about that a different day. But I did go to a patent attorney out of state and ask some questions, and I got an opinion that I had a decent enough shot at a non-provisional patent. Mm-hmm. However, I think this attorney tried to shoot the moon in what they were trying to go for. And they were like, look, you've got 12 months, you got to do this or else you're going to lose all your international rights. And they came back with a large, 5-figure bill of what it would take to do, which on $350,000 in convertible debt, I could not afford. And then additionally, at that point, I had only had, by that point, my second employee. I had 2 developers, but I could not take my time to market was so important. I could not take my CTO off being a developer around the clock to get the beta out and generating revenue. So we didn't have time to draw the diagrams and do all of that stuff. It was too daunting a task. And, then that other attorney was like, look, you're missing your chance. You're going to blow this and you're not going to be able to do anything in the future. And I said, well, your style as an attorney is not for me, and I'll find someone else in the future. But I never applied for that non-provisional patent. Here I am 5 years later. I have a product that's been in 6.5 years later. I have a product that's been in market for 5 years, generating revenue. I never applied for that non-provisional patent. I've raised $5 million without the patent. But now, is there anything I can do to go and remedy this, or is kind of the ship sailed?
Oh, who wants to take that one? Give us the easy one.
Easy
first,
softballs to start the day, right?
Yeah. So if you've been commercializing it for 5 years, that actual product, no, there's nothing you can do except build a brand on it. So I assume that you have some trademark you're using, and but what I would work with you on is, look, are you continuing the development? Are you doing improvements? And, I would work to see if you can, get a patent on those improvements. But, yeah. And you're in a position where if a competitor decides they like your product and they think there's a cheaper way of producing or whatever, they can compete with you and you can't stop them unless it's on the branding side. If they try to make, their product look and feel like yours with what they're calling it, Dan.
Yeah, Pat, and just not knowing what all the details there, there are other IP rights besides patents, right? Very draconian on patents, file it or you lose it. But with these other rights we talked about earlier, trademarks, copyrights, trademark, trade
those.
secrets. That's another area you may want to explore more, because there are really some very, for instance, trade dress, right? So if you have a well-known Coke bottle, right, iconic look to it, and there was a patent on it, by the way, and it expired, right, back in the early 1900s, and then they said, well, we have trade dress protection. So you've got to be creative and look at the different things that you think are your competitive advantages and why people are buying your product, and then try to lean probably a little bit more on some of the other rights as well.
Appreciate it. Yes, I did get trademarks. We copyright our code. We do all the follow-up stuff. So a couple of other questions for you. One of the quotes from Jason in the chat says, when interviewing patent attorneys, what are some questions we as entrepreneurs and inventors can ask to determine if they'll be good for the long haul? And as a follow-up, I'm going to ask you to follow up before you answer that. How do you combat the awful, well, this is the, not my wording, I'm reading the question. How do you combat the awful terms and conditions that larger law firms require their clients to sign in engagement letters? Is it even worth trying to engage nationally firms as a micro entity?
All right, well, okay, I'll start with the larger law firms thing. I mean, there's no, all of us here have worked, at larger firms, and now we're with I worked at a firm, Mike worked at a firm with thousands of attorneys, and now we're a firm with 50. It's the largest in Rhode Island, but it's still not I consider a small firm. I can tell you that our engagement letter is probably one of the, definitely more easygoing engagement letters than what I've seen other places. Those are negotiable to some degree, and I think that you have to counter it as a contract that you're signing. And if there are terms in there that you don't like because you use the word awful, then you should address that with your attorney. Have an honest and open conversation. And that goes back to your other question. I'll let the other two guys talk about this, which is the honesty is incredibly important. You talk about that with your daily life like a mechanic. An honest patent attorney who is going to shepherd you in the right direction, that has the right technical background and will have the right skill set, but to be honest about their limitations, what they can and can't do about that, and also to make sure that they're not doing this sort of, as what you referred to, Pat, is, oh my goodness, the world's going to end if you don't do this by a certain deadline, but more about like, hey, you're at this stage, you only have, $1,000 in your pocket. What can you do with that? And so having that kind of partnership is what you're looking for. The temperament of the attorney, the aggressiveness or non-aggressiveness of them, right? I've actually had some clients of mine I've had prospective clients and friends that are like, I want a junkyard dog. I want an attorney that will bark as loud as I want. And I'm like, that is not me, right? That's just not my style. And that's not the style of most of the of any of the patent attorneys that we have at Adler. So you've really got to find out the temperament, the background, but I think more importantly, that honest and direct communication about where you're going and what IP strategy you're going to employ. Mike?
Yeah, so coming back to the engagement letter, at my previous firm, our engagement letter at the time was over 40 pages. So you literally had to hire your own attorney to review our engagement letter. And at Adler, it's a page long. So it's quite a difference. Then on selection of attorneys, you want somebody that you can get along with, somebody that can explain things to you in a way you can understand it, as opposed to just talking legalese where, and don't hesitate to say, what does that mean? And get explanation. And if they don't want to do that, then, it's not really somebody you want to work with long term. And there's also the issue of retainers. At my previous firm, you can sign, you can engage that firm unless you paid $10,000 of evergreen retainer, which means you had to take $10,000 out of your budget and put it into our bank account forever. So that can be off-putting. Then there's other firms that want to attract early stage clients, and they say, we'll give you the first $10,000 of work. Be suspicious of that, because that $10,000 goes away very quickly. You need to look at their hourly rates, and you want preferably somebody with the right background and the right level of experience for a reasonable hourly rate. I can tell you, if I was at my previous firm, my hourly rate would be a lot higher, to the point where I had to push the work down to junior people in order to get it done. So
we got two more questions. I know we're running tight on time. I want to try to get these in. Maybe we could try to squeeze these in here. Julie asks, is there a way to ensure that IP is owned by a startup versus the third-party development firm?
Yes, set up an agreement, especially if you're paying for the development. You just have to get the right agreement in place that says whatever you develop for us is owned by us. You have to assign it to us. Yeah,
frankly, in all the third-party developer agreements I've done, plus all the PIAAs I've done, that's been very clearly outlined. So that's not an objectionable clause to put in there. Also, the follow-up, is it unrealistic for a startup to expect to patent a UI like Amazon's one-click because it would be too expensive to protect?
Yeah, I mean, a graphical user interface can be protected. You're talking about the one-click patent. It's a very old patent at this point, on the shopping cart. And those are the patents that people point to say, really, is that really a patent? But the other side of the coin is there are people that are getting patents like that. It goes back to what I said earlier. What are your competitive advantages? What is the secret sauce about your business? What's going to drive the revenue of your business? And this is why it's really important that don't just explain the technical aspects of your invention to your patent attorney. Explain the business goals. Explain what makes your business tick. And if you can line that up with, again, if a UI is not important, if it really is going to drive your business, then that may be something that you want to look at. But you have to be realistic and say, it's going to be difficult, maybe expensive, but if that really is what's going to drive the business, then you have to look at it. Mike, any thoughts?
Yeah, no, I agree with you. I don't really have anything else to add.
Yeah.
Hey, one last question before I take this back and wrap up here.
Okay.
We have one from Abigail. I'm going to just read this sight unseen here. I'm a consultant with a uniquely designed process and structure, including a course offering, which may fall, if anywhere, into the squishier categories of trade secrets and know-how mentioned earlier. Are there resources you can point me to start learning the language around what I can or cannot protect and should be thinking about before launching? And frankly, Abigail, I'll tell you that my best way of understanding a lot of that stuff was to sit down and talk to my attorney.
So we have on our website, and I can share this with you, Abigail, a link to what we call the start. Basically, it's like a startup page for basically what we did was we actually hired a consultant to translate the legalese, and let's face it, we do use it too much, into layman's terms, and we've put that on our website under the IP founders area. And so the idea is there, I could give you this and it will explain in kind of an FAQs at a very basic level, trade secrets, know-how, what can be protected, how to go about protecting it. One thing you should know also in addition to that, it's very state specific, okay? So if you're in Rhode Island, there's a Rhode Island trade secret statute. If you're in Massachusetts, there's one there too. There is a uniform trade secret law, but you really want to get nitty gritty on the state that you're in, because that's the state that you're going to have to worry about when you go to enforce your trade secrets.
So Abigail, what I would suggest doing, if you want to send an email to help@rihub.org, RIHUB.org, the folks behind the scenes, Jenny and team, they're going to make sure that they get your email over to Dan so he can follow up with those resources. Okay.
And Pat, today's presentation also, we'll be offering, again, a handout. They can use that same email address if anybody wants a handout from today's session.
And
Fantastic.
I also wrote an article in the licensing journal earlier this year. It was advice for early stage life science companies and how to get them, how to build their IP portfolio, how to prepare for a transaction, and then what transaction to choose. If they want it, we can send it. Just send us an email. We can send you an electronic version of that paper as well.
Excellent. Excellent. So guys, thanks. Thank you, Dan. Thank you, Michael. Thank you, Morali. This has been fantastic. Thank you for your time. As with all our speakers and panelists, this is all volunteer stuff. These are people giving freely of their time to help the startup community. And I think it's truly wonderful.